May I please, Your Lordship? I like to mention item number 12. I'm appearing on behalf of respondent 1 to 3, Your Lordship.
12.
Item number 12.
You are in this case? Yeah, I am the petitioner. 1 week may be given.
So 2 weeks may be granted, Your Lordship.
What happened?
2 weeks may be granted, Your Lordship.
What is the excuse?
My learned counsel is out of station, Your Lordship.
On pre-made by the respondent 1, 2 and 3 not objected to by petitioner. This is matter to 2 weeks.
And also, Lordship, I like to mention item number 14. Yes, on behalf of respondent 1 to 4.
From petitioner, Lordship.
Your Lordship, 2 weeks time may be granted.
Respondent 1 to
1 to 4.
Same order. Respondent 1 to 4. 2 weeks.
Lord, I beg to mention item 13, my lord. Lord, these are the bonded warehouse matters regarding the tender. If your lordships recollect, before the division bench, the policy matter, the state was to reconsider. So, Lord, this matter may be deferred because it will have a direct bearing if the policy changes.
So the subject matter is the same?
No, my lord, this is regarding single tender, but if the policy goes, this will also go, my lord.
When is that matter likely to come up?
My lord, not this week, probably next week. Can have it after 3 or 4 weeks.
Is the Ilman Nongri, learned counsel for the petitioner, submitted that a similar matter dealing with the subject matter present in this petition is also under consideration for the division bench of this court, and decision thereof would have a direct bearing on the merits of this case, and as such we spread that this matter may be deferred for the time being. As prayed for, this is matter after 4 weeks.
4 weeks. Lord, I also beg to mention item 11, my lord. Lord, if this matter can come up after 2 weeks, and for the petitioner.
No objection, Your Lordship.
On pre-made by the petitioner, this is matter after 2 weeks.
Obliged, Lordship.
Yes, Lordship. Lordship, I'd like to make a mention for item 9, Lordship. 10. This matter may come after a week, Lordship.
What is this matter about?
This is regularization, Your Lordship, of this. Which is,
Regularization?
yes, Lordship.
Actually, Your Lordship, 9 and 10 are identical matter. Last time on last date, Mr. Paul, senior advocate, has sought time to need some clarification regarding this case.
What clarification?
Lordship, this will regard that whether she is still in service or instruction.
Okay.
So I pray for
For the government.
So 1 week's time?
2 weeks, Lordship.
You are in both cases, 9
Yes,
and 10?
Lordship, 9 and 10. Similar, Lordship.
On pre-made by the learned counsel for the petitioner, who has prayed that necessary instructions from the petitioner as regard the status of their service is concerned could not be ascertained at the moment. Therefore, it is prayed that some more time may be allowed in this regard. As prayed for, this is matter after 2 weeks.
No obliged, Lordship.
9, 10.
Maybe please your lordship, I would like to mention item number 15 on behalf of my senior SP Mahanta. Due to his ill health, he is unable to present here, your lordship. Your lordship, can the matter be taken after 4 weeks?
Yes, who's for the?
I'm for the state respondent, Your Lordship. We have no objection.
Lordship, I am for NHA.
This is a what is it?
This
Compensation
matter
matter?
is under first appeal under land acquisition.
On pre-made by the appellant on ground of indisposition of the Leonard Senior Counsel, who is conducting the matter. Matter is adjourned. This is after 3 weeks.
Obliged, Lordship.
May it please your lordship, I beg to mention item number 16, my lord. If this matter may come up after 1 week.
She is seeking time for adjournment. I have no objection.
How long?
1 week.
Maybe if asking the time, then it may come up after 2 weeks, lordship.
On pre-made by the parties, this is matter to 2 weeks.
Much obliged.
On supplementary cost list, item number 1.
Hey, Mr. Khan,
Malad.
I was preparing the judgment for this.
Malad.
I think we all have to be blamed. I was looking at your petition, your memo of appeal.
Malad.
And see, I found that number 1, in your grounds of appeal, you have made a mention to the impugned judgment and order, and that is dated 6/8/2021. That's number 1. Then you go to your prayer. Prayer again. Issue notice to the respondent as to why the impugned judgment and order dated 6/8/2021 passed by director so and so should not be set aside. And then again, this date of 6/8/2021 has been mentioned. But you go to the impugned judgment, the date of the judgment is 3/7/2021. So what is what?
Marat, I think since it is mentioned today to be mentioned, I was of the view maybe that something else would be there. So let it come up shortly. I just clarified.
You have to you see, otherwise you see the
Yes,
whole,
yes,
the whole. You see, where is your case? Where is your case? If you have come against a certain judgment and order, which is non-existent for that matter, then how do this court adjudicate?
Yeah. If that be so, means I can file petition.
Look at, see, there's a certified copy of the judgment here.
There might be a clerical mistake.
Look at it, it cannot be clerical mistake. You see, one line could be, but you have mentioned the same thing again and again. That's what I pointed out to you.
Oversight. Just.
I think this is a problem of your copy paste.
Oh shit. Well, I'll get it. I'm sorry.
What do we do then?
I'll file I'll just file it.
I'll file a amended memo of appeal.
Just, if I may be allowed to file a petition for that, for correcting.
Even 152, I don't know whether it will be applicable here or not.
Lordship, it's a appeal. It's not a main petition. Also, I think he has to withdraw this and because he can.
I'll just
withdraw.
I'll just file amended.
You will be the loser.
Yeah, that's
because then you see the whole process has to be. I don't want to go into that. If we can speed up the whatever correction is to be done, the matter can be disposed of. Otherwise,
can we allowed to file a petition for rectification?
Do that.
I'll file it at the earliest.
Do it within 1 week.
Yes.
Give a copy to her.
Correct.
Otherwise,
no.
If you go into that process, then another 2-3 weeks will go.
Correct.
Mr. Ekhan, counsel for the appellant, who has on perusal of the memo of appeal, has admitted that through an advertence, the date of the impugned judgment and order was wrongly noted as 6/8/2021. In the grounds of appeal set out in this memo of appeal, as well as the prayer portion, whereas the impugned judgment, date of the impugned judgment and order reflects date of the is actually 30/7/2021. To this extent, the counsel has submitted that he may be allowed to file an application for rectification. Pray aloud, let the petition be filed within the next date fix with advance copy to the respondent, and the respondent is also to respond to such petition if so advised. This is matter to 2 weeks.
Well, this is with regard to both the analogous or only?
Yeah, it should be both. Same order will be. Yeah? I believe so. I just
check it.
I am giving you 2 weeks. Or let's put it 10 days.
Yes, definitely.
10 days, I think there'll be. So that, in the meantime, if at all you have to respond, you file it, simultaneously. Yes. 2 weeks.
Item number 4.
At the end of the board.
End of the board.
At the end of the board.
End of the board.
Daily costless item number 1.
Please, Your Lordship. Lordship, in this case, the applicant has filed an impleadment application, Your Lordship. I filed my reply also.
Who has sought to be implemented?
Your Lordship, I filed the impleadment applications where my learned friend has filed the objections.
Who are you?
Your Lordship, in the main suit, I added as a respondent in that case.
You are okay.
Yes, Your Lordship. But here, they have not implemented as a respondent, so I filed an application for impleadment, which they have, my learned friend has filed objections to it. So I humbly pray that if the matter can, in this case, can come after a week for hearing, Your Lordship.
Why
Your Lordship, in this case, my learned friend, applicant here, Your Lordship, has filed an impleadment application, claiming himself that he is the lingdo of a Sangrit clan, Your Lordship. Whereas in the original suit, Your Lordship, pending before the civil court, there is no Sangrit clan, Your Lordship. So because it takes back to the compromise deed executed by the deceased, Your Lordship. In this case, the deceased, while executing that compromise deed, she acted in her personal capacity, Your Lordship, not as a member of a Sangrin clan, Your Lordship. Lordship, if Your Lordship can kindly come to the annexed by my learned friend, decision of the Dorbar Sangrin clan.
Where's the?
This is misapplication 156, Your Lordship.
Where is the cause title of the title suit? Where can we find it? In the cause title, he said that he is one of the defendant.
In the main suit, Your Lordship, which is pending before the learned
Exactly.
I'm not disputing the fact that the deceased Slitina Sangren she was the defendant, Your Lordship.
One of the defendants.
Yes, Your Lordship. But the Sangren clan was not involved in that.
That is a different matter.
Yes, Your Lordship.
That is a different matter. If you see one of the defendant is deceased and an application for substitution has been made.
Correct.
Number one. Number two is if you have not read such defendant as a respondent here. So she ought.
My objection is that, Your Lordship, the applicant here is not the legal representative, Your Lordship.
Oh, that has to be.
Yes, Your Lordship.
So the defendant was deceased during before filing of this writ petition.
Because when Slitina
when did she expire?
Your Lordships, today I am handicapped because I have kept my file in the locker and lost the key of the locker. So if Your Lordship can kindly take up tomorrow.
Why didn't you should have called me? I'll come on.
My sincere apology, Your Lordship. In the early morning when I reached the court, I lost it.
You are confidently making your submission.
Because even in the suit, Your Lordship, the deceased has the legal representative.
First, it has to be certain.
It was not substituted.
When she expired.
Lordship.
Whether if it is prior to filing of this petition here, where any steps for substitution has been made, number one, and number two, if she expired in the course of filing of this petition, then of course that's a different issue.
Lordship, if I may, Lordship, because I'm representing the petitioners also as plaintiffs in the suit, Your Lordship. The defendants in that case, where my friend is representing right now, they have not substituted the deceased, Your Lordship, in the suit. So they have just informed the court that so and so has expired, but no names or list of names were furnished before the civil court, Your Lordship. That is the position, Your Lordship, before the trial court.
Whatever the case may be, proper necessary party has to be there. That is for the purpose of a fair adjudication.
Lordship, because Your Lordship, in this case we are against the state authorities, Your Lordship, not the private parties, Your Lordship.
Private parties, for all we know, would definitely be against you in your quest for whatever purpose you have.
Here, Your Lordship, and here in this application, I would like to take my case also, Your Lordship.
Have you filed your response?
I've already filed my response. I've served them a copy also.
Mr. SKO, Learned Counsel, has submitted that an application for impleadment of Shri Betar Sangrin as party respondent has been filed before this court. To this application, the petitioner herein has submitted that an objection has been raised and has been reduced in writing, which is part of these records. It is therefore appropriate that on this limited issue, this matter may be heard. On pre-made by the parties, accordingly, they said application will be heard on the next date fix as prayed for. This matter after 1 week.
1 week.
Much obliged, Lordship.
Obliged.
Item number 6.
Today. Yes.
Yes, Your Lord.
Who's for the respondent?
Lordship, this matter is actually for filing of written argument by both
Have
the
you filed
parties. No, Your Lordship. Your Lordship, there's a connected matter because what happened was the exemption.
Yes, miss, this is your case.
Yes. The exemption which was granted to the petitioner company, Lordship, was subsequently cancelled by the state government.
I do recall that.
Which has been challenged in another writ, that is writ petition number 118 of 2022. So, Your Lordship, this matter is also listed before Your Lordship tomorrow. And it is for filing of rejoinder by us, by me, Your Lordship.
Lordship, here the thing is that I'll say that this case is particularly this case is fixed for filing of written argument. Lordship, the part heard is already done. Lordship was pleased to ask us to file written argument. My written argument is already ready, Lordship. So means like if the case is again coming up tomorrow, Lordship.
No, yes, it may not
tomorrow
survive, because
that is totally different, Lordship. That the matter is
totally different.
Yes,
it is a connected matter.
It may be connected. Maybe it may be related to the said notification.
Yes.
But on its own, the case is already over and done with. The only thing is that you have to file your written argument.
My lord, our written argument is ready, my lord. We'll
Written
file it in
argument.
some time.
Lordship, my also written ready, Lordship. I am ready.
Mr. Thawa, you do file you have not filed.
No, Your Lordship.
You do it. In the meantime, if you have prepared, then you file it.
Lordship.
Then a counsel for the petitioner has opted that the written argument could not be filed today, and has submitted that and has prayed for some more time for the same to be filed. In the meantime, the respondent 1 as well as the respondents 2 to 4 respectively have submitted that the written argument on their part is ready and will be filed in course of the day. Let this written argument be filed accordingly. On pre-made, this is matter after 1 week?
2 weeks, Your Lordship.
2 weeks.
Not only one humble request, my lord, because there are two matters, analogous matters. I think, my lord, it's 83 and 84. My lord, we will file only one written argument.
Lordship, two matters are there,
Two
but
writ
I am
petitions are
filing two writ petitions. But I am filing a common written argument, Lordship.
Where is the
They are listed together. They are listed together.
Item
both the
6,
matters are
6 only, both the matters are listed.
There are two writ petitions.
This
One is
only with the regard to
183.
amount.
Filing only one, my lord.
Lordship, we are
Yes, it is only regarding the period, your lordship. One is regarding a certain period and one is regarding another period.
Lordship,
is the
I am filing a common Lordship for both.
Even I will file common.
So 2 weeks then.
Lordship, I am filing mine now.
Item number 7.
Yes, Your Lordship, in this matter, we need to file the affidavit, so I humbly pray under 2 weeks, Your Lordship.
Your Lordship, this is a 2017 matter.
We just received the RTI, so in that we would like to.
I don't know how will that RTI help now, because the service matter of 2017, appointment of 2017. Now it's 7 years.
The affidavit is ready, Your
Who's the,
Lordship.
what is the case of the petitioner?
They are trying to challenge the selection process. They have participated in the exams. They failed. Now they've turned around again. They've come in to challenge the selection process. They participated. They came out unsuccessful.
We would like to bring and record the RTI, Your Lordship. The RTI.
What is the RTI about?
It's regarding the interview and the board for the post lecture in the government school, government college, Your Lordship. So next week, because the petitioner couldn't get the signature, Your Lordship, that's why. Otherwise, it's ready, Your Lordship.
2017 matter.
That is come after 1 week, then Lordship. That's valid.
Letter counsel for the petitioner has submitted that the affidavit to bring on record particulars of an RTI query made by the petitioner, which according to the petitioner is relevant to the issue raised in this petition, could not be filed today. It is prayed that 1 week's time may be allowed for the same to be filed. It is to be noted that this is a very long pending matter, and as such the petitioner is impressed upon to be diligent in pursuit of a case. The prayer made is allowed. This is matter to 1 week. 1 week,
Yes.
an advance copy to the.
Yes, accept the copy.
And if required to be to be responded to, then you file your response simultaneously.
Just hope they don't give me on the 6th day or 7th day.
No, I will serve before.
So then what do? We'll keep the matter up to 10
We'll
days.
keep it 1 week only, Your Lordship. 1 week. We'll see what happened.
Yes.
Item number 17.
Yes, what is this matter about?
Lordship, this is an anticipatory bail application, Lordship, whereby they have come to before this honorable court. Oh, the learned senior is here, Lordship. Lordship was pleased to direct us to look into decisions with regard to notice under Section 41A CRPC, Lordship. Because their allegation was that the police had reached the house of the applicant to arrest him, but without any service of notice under 41A. And Lordship, we have received instructions, and we have also informed this honorable court to the court's satisfaction that the police had gone there to the resident of the bail applicant for service of notice under 41A, Lordship.
Has the notice been effected?
No, Lordship, because they have come before this honorable court. So accordingly, we had to get instructions as to whether there was any apprehension of arrest without issuing notice under 41A. And we have satisfied this honorable court that the reason the police had gone to Guwahati along with the local police over there was just to give effect to notice under Section 41A, Lordship. So with that being stated before this honorable court, nothing lies, Lordship, because we just want to give effect to notice under Section 41A.
So according to you, there's no cause for apprehension?
No, Lordship, there's no cause for apprehension.
That is recorded, my lord. My purpose is circle.
Please, Lordship. Lordship, the next item number 18, notice under 41A has been effected, Lordship. Lordship, I can place the case there, Lordship.
So if that's the case, then, because you see, once notice under Section 41A has been served, there is no question of arrest. No question
Actually,
of arrest.
that is not happening.
So firstly, there's no question of arrest. So there is no apprehension as such. Of course, if reason is to be given later, you will still be, given notice.
But that is where there is some ambiguity, my lord. Because if you lots of recollect, on last occasion I argued that for issuance of 41A notice, my lord, supposing that one accused person has been issued a 41A notice, my lord, he responds to that and goes to IO, my lord. Especially where offence is punishable by 2 years, 3 years, my lord. Now it is totally at the discretion of IO, my lord, as it stands today. That recording reason is it will take 2 minutes, my lord. If he wants to arrest even without any justifiable reason, my lord, he arrests.
Lordship, I think the magistrate also comes in place over here. It's not exactly, Lordship. It's not at the whims and the fancies of the IO, Lordship.
My lord, that was the precise question on last occasion. I placed, my lord, one judgment from Telangana High Court, which said that after issuance of 41A notice, if police further requires to arrest that person, my lord, police must get an order from magistrate.
Lordship, on the 31st of July 2023, the Honorable Supreme Court was pleased to again keep in consideration that Anish Kumar's guidelines should be followed. This is going on till date, Lordship.
We are not on that.
No, Lordship, I'm surprised about the apprehension coming from my senior.
My lord, if there is no apprehension, if that is the statement from the government, my lord.
Yeah, that's what he said.
That's what, Lordship. As per the allegation that we had gone for arrest, but we had informed this honorable court, and the WT has also been submitted to this honorable court, that the reason the police had gone to the residence of the applicant is because to give effect to notice under 41A, Lordship.
It may help, but then in case I state that upon serving of the 41A notice to the petitioner in item number 18, the petitioner also stated that as a told a petitioner to that he may also help out and tell the petitioner in item 17, Sandeep Kumar, to approach the office or the police station, but then and also
Anyway, you see, Mr. Karwalang,
and no arrest have been taken.
no, the fact is, it has been submitted at the bar. Firstly, from the prosecution side, that the only action taken by the police so far is to try and serve or affect the notice under section 41A, to which there may have been some misapprehension, put it that way, by the petitioner, that they may have come to arrest him. So now that the record has been set straight now. So what the petitioner now standing at the bar would be assured that section notice under section 41A would be served upon him.
Lordship.
So he would accept it in due course once it is served.
Lordship.
Receive it. So that's the end of the matter as far as this petition is concerned.
Lordship, if I may, the residence of the applicant is in Guwahati, Lordship, and twice the police from Birnihat have travelled there, had to seek the assistance of the local police along with the women police, went to the residence, Lordship, twice, Lordship.
Dr. Musika can advise him.
Lordship.
Lordship will only record that, madam. There is no.
Yes, that is why.
No apprehension of arrest.
No, Lordship. What I'm saying is to give effect to 41A. He cannot force that, Lordship.
My lord, that was the statement clearly made. I think everybody heard that there is no apprehension of arrest.
That is why. See, once section notice under section 41A is concerned, at that point of time, see, we are not talking about later.
Later,
what
exactly.
Later is a different matter.
Yes.
At that point of time, there is no question of apprehension. Once there is no apprehension, no application under 4038 will lie. That's number one. If later, as is provided under
the difficulty, my lord, he responds to 41A notice basically to come to police station. He'll go to police station, my lord. Then and there they'll arrest him.
No,
Lordship,
that will be recorded.
Lordship.
That will be recorded.
Anish Kumar's
offences.
My lord, that is what has happened.
Is followed till date.
In so many matters, my lord.
Of course, in that case, then the court will have to
exactly, Lordship. That's a separate matter altogether.
Then the court will have to, pass necessary, observation.
Lordship. But as far as
my lord, I know for a fact that 41A notice was issued in the coal matters, my lord, by Salang police station. When people went to in compliance with 41A, they were arrested then and there.
And you can raise that in that issue, Leonard Senior, not here.
That is a different issue.
Yes.
Because my lord, Ernest Kumar, your lordship recollects on the first day when I was moving the bill application, your lordship to some extent agreed with me that there is no protection to that effect, my lord, anywhere. Ernest Kumar also does not exactly touch that aspect. And then in Telangana High Court, the recent order, my lord, that once 41A notice has been issued, police cannot directly arrest. If police still requires to arrest,
that is why you see the provision is very clear.
Is there,
if they are required to arrest him, they will give reason.
My lord, the difference. Police cannot give reason, my lord. Police has to.
Of course, they may approach the MIC for all we know. That's what I think 41 says.
Maybe with the exception of Telangana, Lordship, entire country is following Anish Kumar's guidelines.
You look at 41A.
Lordship.
But there is some gap between subsection 3 and subsection 4, my lord. 3 says, my lord,
where such person complies and continues to comply with the notice, he shall not be arrested in respect of the offence referred to in the notice unless for reasons to be recorded the police officer is of the opinion that he ought to be arrested. 4 says, my lord, where such person at any time fails to comply with the terms of the notice or is unwilling to identify himself, the police officer may, subject to such orders as may have been passed by the competent court in this behalf, arrest him for the offence mentioned in the notice. And 3 says, my lord, magistrate's intervention is not required. 4 says, subject to such order as may be passed by the magistrate.
No, if he fails to comply.
Fails to comply, Lordship, it's very clear. Explicitly mentioned over
Because
there.
3 presupposes a situation where the notice has been served upon him.
My lord.
So, number 4, subsection 4 says that if he fails to comply or is unwilling to identify himself, meaning he refused to accept notice,
Lordship,
then what would be the recourse taken by the police then?
Lordship.
It would be to get a competent order from a competent court, meaning magistrate, and the person will be arrested.
Lordship.
So,
but
once you see the thing is this: as far as subsection 3 is concerned, once you accept notice, you cannot be arrested.
Cannot be arrested.
That's what it is.
It's explicitly mentioned here, Lordship. And once he accepts notice, he has to cooperate with the police.
The Telangana High Court is very explicitly clarified that, my lord. If that clarification is given, my lord, this will help everyone, not only me, my lord.
Lordship, that has not been brought on board through the pleadings, Lordship. Because here what they're mainly concerned is the approach of the police, Lordship. And we have clarified, Lordship, from the prosecution. They've gone there just to give effect service of notice under 41A. In fact, they're evading us from giving effect the notice under section 41A, Lordship.
Miss, the only thing is that you read subsection 3 carefully.
Lordship.
You'll find that the first part is if he complies
and continues to comply,
then he continues to comply, he
shall not be arrested, Lordship.
But then the second part says that
in respect,
unless for reasons to be recorded, the police officer is of the opinion that he ought to be arrested.
Lordship.
So what does it mean?
Lordship, when a person appears before the authorities under 41A after having given effect, Lordship, if he makes a statement whereby some recovery is made or anything, Lordship.
Or he pleads himself.
Yeah, we don't know, Lordship. We don't know.
No, but and this is a big, not big, but
there is ambiguity, my lord, in subsection 3 and subsection 4. But in my ambassador, there should be some certainty in law, my lord. If law, there is ambiguity in the law itself, my lord, where the citizen will go, my lord. It is a total mercy of the police officer, my lord. 2 lines, the police officer will record that he is not complying. Not complying in what sense, my lord? The Supreme Court has said in one of the very recent decisions, my lord, that compliance with 41A notice doesn't mean that he has to go and admit the crime, my lord. If it is taken to that level, my lord, and that is what is happening, that if he confesses to the crime before the police, that if that is a compliance, my lord, that cannot be compliance, my lord.
It's not in each and every case that 41A is for. I don't understand where this is leading, Lordship. Lordship, this Honorable Court has been clarified of the fact that we have gone to the residents to give effect of notice, Lordship, under 41A. And that was the clarification sought for by this Honorable Court.
My lord, 41A notice is one thing, my lord, and my apprehension of arrest does not end with 41A notice, my lord. That is my humble submission, my lord.
Lordship, first of all, the applicant is evading giving effect of notice under 41A, and now he's coming up with another apprehension. We don't understand, Lordship. He's not cooperating with the investigating authorities. They are taking advantage of this Honorable Court's indulgence, Lordship, for having deferred this matter for more than a month, Lordship. This is an anticipatory bail, my lord. They're enjoying the interim protection of this Honorable Court. No. You are going far. No, you should also stop, Senior. I'm sorry. Because this has gone on for more than 1 month, Lordship.
My lord, the accused person, your Lordship recollect, there is another matter which your counsel from Guwahati is appearing, my lord. Lordship has granted interim protection to him. Pursuant to that, he has gone to same IO, my lord, on 29th of July.
Same person?
Same person, my lord. My friend is submitting without any instruction, my lord.
I'm submitting with instructions. We've gone to give effect 41A, and they're evading that also twice, Lordship. This is in Guwahati.
If my friend is not talking, my lord, I do not know, my lord, what to say also.
I'm also surprised with what is being brought on board, Lordship.
Anyway, the fact remains.
My lord, let us simplify, my lord, as far as I am concerned. If Lordship holds that 41A notice, there is no threat of arrest, by recording that, Lordship can close the matter, then I am safe, my lord. Or if Lordship says that after 41A notice also, the threat of arrest is still subsists, my lord, still remains, then I am praying for anticipated bail, my lord. It was a minor offences, my lord.
That we are not aware, Lordship.
Objecting for the sake of objecting, there is no point.
Very unfortunate that the learned senior is making such comments, Lordship, for the sake of objecting. He has his loyal to his clients, we are loyal to the state, Lordship.
But you see, whatever submission is made or reference is made to the law, it has to be in the context of the facts and circumstances.
Lordship.
You cannot go beyond, like you rightly said, you cannot go beyond pleading. The only concern that this court has is with regard to the interpretation of this provision of subsection
3 and subsection 4. There is ambiguity, my lord. Even Ernest Kumar does not clarify, my lord, that aspect.
See, because if you read the purport of section 438, it simply says that if there is an apprehension of arrest, then such person is entitled to come before the court.
Right.
Number two, but here the question is, when a notice under section 41A is issued, it is very clearly stated that he shall not be arrested, or there will be no arrest in respect of such offence. In the same breath, it says unless, you see, for reasons to be recorded, the police officer is of the opinion that he ought to be arrested. So what does it mean?
So depending upon the statement,
see, this gives a very, very vast area of discretion to the police officer to arrest a person in spite of issuance of notice under section 41A. Reasons may be given, rightly, wrongly, we don't know, but then he may be arrested. So where's the question of application of the principle of apprehension there to allow the person to come before competent court?
Because what happens when
this has to be clarified by relevant authorities. You have
the Telangana High Court judgment, my lord.
What about Supreme Court?
Supreme Court has not gone.
No, Lordship. All over India, we're still following Anish Kumar's case, Lordship.
Because subsection 4 again says that magistrate's order, my lord. It talks about magistrate's order.
Yes, again. Yes, that is
so read 3 and 4 together, my lord. That's what the Telangana High Court has done. Drawing from subsection 4, my lord, and subsection 3, that in that event, after 41A notice, if the accused appears and police feels that he should be arrested, magistrate should first go to court and get an order. Yes. That he can do in 1 day's time, my lord. For 41A notice, the police can wait for 15 days, my lord. Why can't they wait for another 1 day to get a...
That we cannot control, you see. Now that would depend on the wisdom of the IO. How he handles the case, that is not for us to decide. For all we know, it could be very simple case, on the surface. It could be something else when it is investigated into. That's a different matter. But the fact remains, yes, if the police officer has reason to believe that he ought to be arrested, so a report has to be placed before the magistrate concerned.
That I want to arrest him for this region and get an order from magistrate.
The magistrate will issue the order.
That's the law, Lordship.
But in the meantime, he would not be subjected to custody.
Exactly, man. Till then, till he gets an order from magistrate.
It could be a matter of 1-2 hours. It could be a matter of
1 day,
or more.
Because 41-day notice, police is waiting in any case, my lord, for 1 week or 10 days, my lord.
So you see, let's imagine a scenario where the petitioner receives a notice under
41A
section
notice,
41A. He,
To appear on so
he
and so
goes
date.
before the IO.
My lord.
IO, questions him, note down his statement, whatever the case may be,
Lordship.
and then release him. Immediately he finds that no, he has reason to believe that he is to be arrested.
He should be arrested.
So
police should file an application.
by the time
immediately
he's
for
already
arrested.
left the the prison,
Because that apprehension will not come because 41A notice is in compliance to that. He has to come to police station, my lord. So once a warrant is there, my lord,
Lordship,
definitely will come. My lord.
it says for reasons to be recorded. So, and Lordship, my friend is appearing in the next matter, Lordship. It's a connected matter. This is just an extract of the CD, Lordship, dated 12th of June 2023, Lordship, if I may read, Lordship. Notice under section 41A CRPC. It is to be noted that here that today, 12/6/2023, notice under section 41A CRPC is served to Deepak Kumar Chaudhary, and he duly put his signature on it. Further, he is directed to inform this applicant, Lordship, and Chotu Khan to appear at Birnihat OP for the instant case. I have also clearly informed him that they will not be arrested and they have to cooperate with the police for the interest of the investigation. Deepak Kumar Chaudhary also promised to convey the message to the applicant herein, Lordship, and he cited that he doubts that the applicant herein will come before the police even if he informs him, because he does not talk to me since the time his companies were shut down. But if you go to his house in the evening, he will be there.
Oh, that's of course.
Lordship, I thought I should just apprise this honourable court of the...
Those are factual aspects.
Lordship. These are the efforts made by the investigating agency to investigate, Lordship, and to come to a conclusion whether to file charge sheet or not, or whichever, Lordship, whatever is decided by the investigating authorities.
Your observation is there.
We are not on.
Observation is there that you are not to be arrested. So I think we'll leave it at that.
Lordship.
On the basis of that, my lord. So, I was praying like this aspect could be clarified, my lord. It will bring a lot of clarity everywhere, in the entire state. This was the right case for that, my lord.
It would be good because this court is also of the opinion that this matter has to be clarified, like you said, because that ambiguity between 3 and 4 and the reasons and the time factor, all those things will come to play. And the issue of whether adequate time is given to the accused, informing him that he is to be arrested and all those things, whether that will come in the picture or not, to allow him to make some application before any competent court.
Because that is only because in good faith he goes to police station, my lord, hoping that he will not be arrested because he has been issued a 41A notice. Police records 2 lines, my lord, there that I am satisfied he should be arrested. Arrests him, my lord. He doesn't get a time also to file an anticipated bill that time, my lord.
No, that will not be.
That's not possible, my lord. Because in the police station.
See, again, we come back to 4. Even if he has reason, under 3 he has reason to believe that he is to be arrested, he still has to go to 4. That means go before the magistrate and get the order.
But that
would take some time.
That has not.
See,
that is not being
in the
followed.
meantime, you see, in the meantime, he cannot arrest that person.
Watch it.
In the meantime, like I said, it could be a matter of 1 hour, 2 hours, or 1 day or whatever. He could not arrest him until and unless he gets the order of the magistrate. Then he goes and arrests him.
My lord, in the present circumstances, nothing has happened. Not even service of notice has happened,
We are not
Lordship.
talking about this. We are talking about the concept as a whole. So if we go into that aspect, it's a different thing altogether. But like going to the facts and circumstances of this case, the matter is clear. There's no apprehension. That has been clearly stated by the IO.
Lordship, allow us to serve notice first under 41A, Lordship.
Let us see if, as and when this matter comes up, at an opportune time, and then we'll look into it.
Lordship.
But was granting anticipatory or?
No, just recorded.
There's no apprehension.
There's no apprehension. In the light of what has been submitted.
Lordship.
Provided you appear before the IO.
In other case, I've gone and appeared, my lord. Because in this matter, because that ambiguity is still there, I can still be arrested, my lord.
heard Ms. Angela Larat, Senior GA, who has submitted that the stand of the prosecution in this case is that the issue of the question of apprehension on the part of the petitioner as far as arrest is concerned is unfounded, inasmuch as the step taken by the prosecution is only for issuance of for affecting the issuance of notice under section 41A CRPC, which could not be affected due to the fact that the petitioner could not be located at his place of residence, at his known place of residence. Therefore, the stage is only at the stage. Therefore, if the notice under section 41A is affected, the provision itself provides that no arrest can be made immediately. The letter Senior G has also referred to a noting in the case diary. Is it the same case or different case?
Same case, Lordship.
No connected, but the same FIR.
Same FIR, Lordship.
But different accused.
Different accused, Lordship. There are more than 2 accused, actually, Lordship.
Oh, then it's
at the last portion of this page, Lordship.
I'm sure I do. Yeah. Next day. Noting this CD, wherein the investigating officer, while affecting notice under section 41A to another co-accused in this case, has directed him to inform the petitioner hearing and another co-accused person and another person to appear before the Bernihat OP outpost. It is therefore incumbent upon the petitioner to appear before the IO and to acknowledge receipt of the said notice under section 41A. Dr. N. Musica, learned senior counsel appearing for the petitioner, has submitted that the petitioner would comply with the request made by the IO and would acknowledge receipt of the notice under section 41A as and when it is served upon him, and would also appear before the said IO as and when directed. Since the prosecution has categorically submitted that no arrest has been made, no arrest will be made pursuant to notice under section 41A being issued. Therefore, at this stage, there will be no cause of apprehension of arrest. It is prayed that necessary orders may be passed in this regard. This court, on consideration of the submission made, would firstly observe that it is imperative for the petitioner to cooperate with due process of law and to acknowledge receipt of the said notice under section 41A and to appear before the IO as and when directed. Again, if and when the said notice under section 41A is effected upon the petitioner, the submission made at the bar by the learned senior AG, senior GA, that no arrest will be made is taken note of, and to this extent this court would agree that no apprehension is made out to qualify an application under section 438 CRPC. Accordingly, in view of the observation made here and above, this petition is disposed of. Before parting, this court would request the petitioner to immediately appear before the IO tomorrow
within 3 days time.
Within
I do not know exactly where he is.
Within 3 days from today, and the IO is to effect issue of a notice under section 41A on his appearance. It goes without saying that no arrest should be made in keeping with the provisions of section 41A. In view of the above, petition disposal.
Much obliged, Lordship.
That would satisfy all.
Everyone satisfied with
Like they say, it's a win-win situation.
Lordship.
You still can arrest him.
Lordship, we can.
And he still can,
Lordship.
get his opportunity to be to.
Lordship. I will
file
be following
appropriate
the
application.
provisions of law, Lordship. Much obliged, Lordship.
The next matter, he has been served with 41A, that was reflected, my lord, just now, and he has appeared before the High also, my lord.
That is the CD of the Lordship.
But the CD you said is for both the cases, isn't it?
Lordship. No, connected, Lordship.
And he was served on the 12th of June, Lordship. Until now, there was no arrest or anything. He's
Oh, 12 June. Then
June, Lordship.
We have received 41A notice. He has went and
Then why have you filed this application?
well, only because of that apprehension, my lord. 41A does not totally clear the apprehension, my lord. I think the same submission can be recorded. He will not be arrested.
No. In that case, you see, there is no issue. There's no ground for filing this.
Lordship.
21 June is over and
12th June, Lordship. 12th June.
12 June.
Lordship.
See, now we're in August.
August. 2 months later.
You have not been arrested so far.
So far, he is not
No
been
reason
arrested,
has been
my lord.
given.
So far, he has not been arrested, my lord. But
If
my lord, police
if
at
he
this stage
apprehends
want-
arrest in spite of the issuance of a section notice under section 41, then you have another cause of action, not in this petition.
after arrested, I have to file regular bail application only, my lord.
No, if you have if there's an apprehension of arrest in course of the post issuance of the notice under 41A, then you can come. But now you have come here
Well, the
with
difficulty
an
then there will be
apprehension.
no time for us, my lord, to approach the court, my lord.
No, there definitely there will be. Why not? As of now, you have not been arrested.
As of now, I have not been
So
arrested.
you
my
are
lord.
roaming around.
My lord, my only apprehension, my lord, tomorrow, again, suppose the police IO calls him, tomorrow he appears, my lord. And on the spot, my lord, police arrest
that
him,
will
there is no
not-
protection, my lord.
If you appear, then the IO, it's incumbent upon the IO not to arrest you. But if you get wind of any indication that you are likely to be arrested, then you can come before the court. I think that's the only
My
situation.
lord, IO will not say that you go and approach the court, until then I will not arrest you, my lord. That's the only thing.
No, that is for you to to find out. Fine.
My lord, similar protection is given like in the earlier order, my lord. There's
No.
apprehension of arrest.
Heard Mr. H. Karolang, Leonard. Additional senior GA who has submitted that the case diary is produced for this court today, and on perusal of the said case diary, it would appear that the petitioner herein has no cause of apprehension of arrest, inasmuch as this notice under section 41A has already been affected upon him since 12th June 2023, and he has been how many times has he appeared?
Our lordship is not part of diary, lordship, you know. Also, I have to see the instructions on.
It doesn't matter. Just if you could make a guess, once or twice or thrice. How many times has he appeared before?
Lordship out here, as per the case diary, lordship is.
Should be twice, my lord, but I don't have the exact date, my lord.
Last noting in case diary is dated 12th June, lordship. I don't have the.
It's not their lordship. And on that day, he had appeared before the prosecution
That day had appeared, lordship.
on 12th June.
Coming to go, the last line. Though there is no record at present to show as to how many times the petitioner has appeared before the IO, suffice it to say that on the 12th of June he has indeed appeared before the IO, and most probably his statement must have been, his statement has been recorded. Is it here?
On 12th, Lordship?
On 12th.
Yes, Lordship.
Lordship, it is to be noted that today on 12 June 2023, notice under section 41A is served to Deepak Chaudhary, Kumar Chaudhary, and he duly put his signature on it.
No, whether he has been, his statement was recorded or not.
No, Lordship.
Usually it is. It should be. Nothing is there. Oh, belum tukang last line tu statement. Stop right there. In view of the above stated position, the additional senior GA has submitted that there is no cause of apprehension of arrest as regard the petitioner herein, and as such this petition is devoid of merit. The same is liable to be dismissed. Dr. N. Musica, learned counsel for the petitioner, on the other hand, has submitted that it is indeed a fact that the petitioner has received the notice under section 41A and has also met the IO on 12th June. However, it is the lingering fear of the petitioner that he may be arrested at any point of time in connection with the related PS case number 444 of 2023, for which this application is accordingly filed for this court. This court, having heard the argument advanced by the parties herein, would observe that the provision of section 41A CRPC is very explicit, in as much as once a notice under section 41A has been issued, the noticee would not be arrested unless reasons are given by the IO to affect his arrest. Some time has elapsed since 12th June 2023. Until date, there is no indication or inkling of any arrest to be made as far as the petitioner is concerned. This would demonstrate the fact that there is no apprehension whatsoever. Accordingly, on the assurance that the petitioner would not be arrested pursuant to the said to the issuance of the said notice under section 41A, this petition is accordingly disposed of. Petition disposed of, but no cause. Do you require the CD you sent given?
No, also there's a copy.
So that would also cover you.
But Lordship, if it's as per 41A4, If the petitioner fails to comply with the notice.
That is a different thing. If he fails to comply, then you take your steps accordingly.
Much obliged.
Second call from supplementary cause list, item number 4.
Mr. Sen, I've heard you on the issue of maintainability. But in the meantime, I think those interveners, they also have to be heard.
In fact, what had been expressed by Mr. Chirag was that they have nothing to say insofar as the question of maintainability is concerned.
Did he?
Conveyed this to me.
He told you in the corridor?
No, in the court. I had asked him if he wanted to argue, because Lordships will recall this matter has come up thrice after that.
Exactly.
So he did not argue, and he told me he had nothing to say on the question of maintainability, but he would argue on the main matter.
He should have been here to say so. Otherwise, this court would be under the impression that he may have something to say. Since his intervening application has been allowed.
Yes.
And similarly, Mr. Nongri.
But he's not opposing our revision application.
Again, he has to say something.
If Lordships recall, he had mentioned this before the court when we were talking of this. They have no opposition insofar as our maintainability is concerned.
Has that been noted?
I don't think this has been noted, my lords. But anyway, the question of maintainability was raised by my learned senior friend, and I had advanced my arguments on that.
See, that would be taken care of, of course.
So it's only waiting for...
so as not to delay the proceedings, and after you've had your say, somebody comes and say, no, we also would like to say something, then, matter will linger.
Well, it is their responsibility to be present before the court. It is their responsibility.
Yes, it is. Are they around? See, because nowadays, since we have 2 or 3 courts, going on simultaneously, they may be in some court. You can just, if they are wrong, otherwise I'll hear you. So there's no question of reconciliation or settlement or anything.
My lord, we have offered whatever they wanted, whatever is the dispute, my lord. The dispute only is that we have to allow the 8 suitors from Mr. Philemon Nongbri's client, my lord. We have written to them that we are agreeing to that. What you want 8 suitors from their group. You take it. Nothing remains after that, my lord. Well, it is in a money suit, my lord. They demand money that I'm not paying. I'm paying them money. What were the cause of action survives, my lord? But they said no, we'll not take it the money now.
But I think later on the issue of your cancellation of your license has come.
Well, during the pendency of the matter.
Suspension or cancellation?
Is non-renewal, my lord.
Non-renewal.
Non-renewal on the ground that matter is sub judice before the court.
Oh. So if the matter is settled before the court, then it may be renewed or not.
My lord. For the renewal also there are certain guidelines for that, when a license is to be renewed and when not to be renewed. It cannot be that they'll sit over it, my lord, and they'll return it, our application for renewal, my lord, on the ground that matter is sub judice. And then say, no, now you cannot.
This is the problem with civil proceedings. You get the trunk, and finally you get branches, and you have to deal with the branches, and we lose sight of what is there in the trunk.
Well, even today at the bar I can make a submission, my lord, that whatever was their claim, that you give them 8 suitors, my lord, out of 50. Even I can make a statement now only.
Mr. Sen, would you be satisfied with that?
Lordships, I have taken instruction. I'm not in a position to make any concessions, but while Lordships will recall, this matter has been pending on the issue of settlement for quite some time.
Exactly.
I had taken this to the department. Departments are very clear. There was no talk of settlement at all, and they are not interested in the settlement.
But if you see, at the end of the day,
Lordship.
he is conceding to first. If I could recollect you correctly, I may be wrong. There was that issue of you not allowing those shooters to
some shooters, but because they were fighting among themselves,
some organization to participate. So then the matter started from there.
So they issued a direction to us that you have to allow these eight shooters from that group.
And then went to court, so on and so forth. So now at the end of the day, he says that okay, you come, we'll allow you.
Lordship.
So that would have solved the matter.
From what I understand, substantially that entire position has changed. Substantially.
Exactly.
It does not remain the same as it was in 2016 or 2021. That entire thing is materially changed. So they cannot revert back to that original position in any case. They've introduced a new organization for running these games. Now there are two sets of organizations. So materially everything has changed, my lords.
Who has it?
Mr. Philemon Nongbri's clients.
How does he come in the picture?
They have been issued a fresh license.
By the government?
Lorships, by the government.
Okay.
They're holding it
instead of the petition. Instead of the.
So petitioners are running it. They were running it right from the start, from 2016 onwards, and there were different arrangements with the different shooters and different other organizations. Presently, after 2016, some of the organizations were suspended. Their shooters were absorbed by the petitioners, by the respondents. Mr. Philemon Nongbri's clients are the latest entrants in this matter. They are holding their games in Lightning Court.
How long you been doing it in Polo?
They've been doing it in Polo, in a property which has been leased out, a private property, as far as I understand correctly.
So that's where the.
But I have taken this to the department in all earnest. I've taken it to the department. They are not interested. We can't really force them. They have their own reasons, and they say that the position has changed completely.
But these were the people, my lord, whom we said that because of for some reason, those are precisely the people who have been given a new license, my lord.
Okay. They are the one whom you have shunted out.
My lord. So government is siding with is so obvious, my lord.
Anyway, as Mr. Sen has said, he has done his part. We cannot force. Only.
Well, Learned Senior Counsel also asked me to speak to the government. I have from my side the best that I can do. If they are not interested, we can't really force them.
My lord, interested, my lord, it is not a question settlement. It's not even settlement, my lord. I am conceding totally what they want, my lord. It's not a settlement that I am giving you something, you give me something. That is settlement, my lord. That requires mediation, conciliation, my lord. Here, whatever you want, I am giving it to you. After that, my lord.
But in the meantime, as Mr. Sen has said, see, some development has taken place. There are new entrants now.
They are for Lightning Court, my lord, not for Shillong, my lord.
No, the games are for Shillong. That's a different issue altogether. It's not before this court, but there is a different dispute altogether. They wanted to start the games in Shillong. This was physically stopped by certain NGOs. Now, I don't want to go into that issue, but as a result, they were forced to have it in Lightning Court. Otherwise, they intended to have those games in Shillong itself. But because there was going to be a law and order situation, a clash between the respondents and the new entrants, as a result of which they moved to Lightning Court. Only for the sake of law and order. That's all. Because if Lordships go through the case, even in 2016, there was a serious law and order issue. But anyway, that will not be relevant for the present purpose, Manoj. Here only there's a very small issue involved. Whether they were entitled to that stay order by the trial court.
Yes, no, that, like I said, that is the branch.
So whatever orders they were seeking a stay of, that has already been stayed by the 2016 orders have been stayed by the learned trial court. That is a subject matter to a different challenge. In 36, we're only on the issue of the license. So that is not connected, if I understand correctly. That issue is not really connected with the main suit or the status quo that is to be maintained and their prayer before the trial court that the pre-2016 situation should be maintained. Trial court has granted stay orders protecting their position. So we are only on a different issue.
Yes, of course. This is
settlement I have tried. My learned senior had represented to me. I took it to the government, spoke to the commissioners. If they are not interested, we can't really spend so much time on the same issue.
Yes.
Today.
Today is a good day, my lords, a very auspicious day because my learned senior is not engaged in the division bench, which is why I had prayed that the matter can be taken up today. Otherwise, I understand their difficulty. They are engaged in the division bench with Union of India matters.
Not many
I'm
matters.
trying to be as fair as possible, my lords. So they have taken a lot of time from this court.
Yes. This has been going on for quite some time.
We're already in the month of August.
Right now, the situation, if you look at a broader picture of the thing, the other group is also happy. They're shooting at Lightning Court, my lord. We are happy shooting at Shillong, my lord. Everything is running so well, my lord. There's absolutely no problem anywhere, my lord.
But you're shooting San's license.
Correct. Only on the basis of a protection order issued by the trial court.
My lord, we are there since 1982, my lord. And what accentuated this kind of scenario, my lord?
That too, of course. Court cannot go into issues of ego, and otherwise it could be differences of opinion, whatever. Those are, at the personal level.
And also, the settlement has to be voluntary. If there must be some reason, whatever political reason or non-political reason why they're not entertaining their requests.
But as Dr. Muzika said, you see, it's not an issue of settlement. It's an issue of concession.
No, that's what's being said today. Even before the trial court in 2020 or 2021, when this came up, they had made their offer of the settlement, but with certain conditions. Which conditions were not acceptable by the government.
But now they say no conditions.
I'm not aware. Again, my lords, they've already taken this to the government. They've represented this before the government. If they're not interested, I can't really. All I would pray, my lords, the main matter is still pending. They can still pursue a settlement. I'm only on this issue of this miscase, my lords.
Once this miscase is decided, either
this will be kept hanging. I understand this because this is my own experience since last year. We've tried the settlement. It's not working out for whatever reasons. So every time the matter comes up for hearing and we find an occasion to do it, if they say we want to try and settlement, we want to try a settlement again, that is just to delay the process.
We are past that.
But in fact, I told why settlement is not fructified till now. I very candidly told my friend, which I cannot submit in open court.
Well, that is true. You have also indicated in not many words, that there are certain extraneous factors,
many factors
which cannot be, legally, looked into. But then that's a different aspect.
So I'm only praying once 3 issues to be decided by this court today.
Yes,
we're not even on the main issue. We're only on the issue of maintainability.
Yes. So,
maintainability is first.
Again, who are the other parties? Your respondent? I think the course title has to be
amended. It's not been amended.
Initially, there was only one respondent.
Yes, we have
Lordships had directed that. Lordships had directed that day.
But it's not showing here. Even add to the respondent name.
CRP number 36.
Or 36. Can you read
The wrong one is before Lordships. There are 2 which are tagged. 36 is the one where the impleadment was caused.
Yes. So you are for? Okay, so 3, 4.
Basically the bookies.
And 2, you are 2.
Your Lordship, of the neutral indigenous archery organizers institute.
What is your stand in this issue?
But in respect of the maintainability, now they've come under 227. This order has been passed by the Assistant District Judge when an appeal would lie. I think maintainability, that's the first issue which has to be decided by this court.
Yes, of course.
Whether against the impinged order, can they come by way of 227? So subject to what my learned friend says.
So, but,
okay, so you would be taking a similar stand
Yes.
as far as the respondent one is concerned.
Regarding maintainability, without going to the merits of the case.
Yes, of course. That we are only on the issue of maintainability. And as far as 2 is concerned, yes, Mr. What is your stand?
Your Lordship, Mr. Philemon Omri is ruling on his legs.
Yes.
So, Mr. Nomri is on legs.
Oh.
Again, that's
the court will not follow.
We'll hear you later.
Well,
Please.
My lord, maintainability I have challenged on 3 counts, my lord. First ground I have taken, my lord, that all the parties in the suit, my lord, were not represented, were not arrayed as party in the present revision, my lord. That was the first ground I have taken, my lord. And in that regard, I had on earlier occasions cited 2 decisions, my lord. One was from Gujarat High Court and one from Punjab and Haryana High Court, my lord.
What is the citation again?
But one is notified area committee.
What is the
citation? Is
citation?
ILR volume 12.
ILR?
ILR, Indian Law Review, volume 12, 1066, Punjab and Haryana. And second citation was, my lord, 2012 SCC online.
2012 volume?
It's 2012 SCC online, then Rajasthan.
Oh, SCC online, sorry. I thought.
SCC online. Then RAJ Rajasthan, RAJ 652.
Relevant para? In the first case also, what is the relevant?
But in the first case, the relevant para would be the concluding paragraph. It is not exactly numbered, this paragraph here. And the second one, para 7.
Can you read out that?
Yes,
motion?
May I first refer to the Rajasthan one, 2012 SCC online.
It's not here. I have this Punjab case here.
Punjab is there, man?
Punjab is here, but that Rajasthan is not here.
You have extra copy?
I have a copy.
Para 7. At the outset, it is required to be noted that though the appellant plaintiff had filed the suit against the Para 7.
Yes.
At the outset, it is required to be noted that though the appellant plaintiff has filed the suit against the present defendant and 3 others, the present appeal is filed only against the respondent JDA, original defendant number 1, without joining the other defendants, that is defendants number 2 to 4, as party respondents in the present appeal. On the query put by the court, the learned counsel, Mr. Kasliwal, submitted that since the injunction was sought only against the respondent defendant number 1, the other defendants were not joined as party respondent in the present appeal. The said submission of Mr. Kasliwal is not acceptable for the simple reason that the appellant plaintiff, having filed the suit for declaration and permanent injunction against all the defendants would be necessary as well as the proper parties in TI application as well as in the present appeal arising out of the order passed in TI application. But the basic idea being, my lord, the appeal or revision are a continuation of the proceedings, my lord, of the original proceedings. So it will lead to some kind of absurdity at some point of time, my lord, that there are different parties in the original suit, my lord. There are different parties in first appeal, for example, before this honorable court, and matter goes to, for example, in SLP, my lord, there are some different parties, my lord. Now, there can be several arguments, as Mr. Senate submitted, but what is the harm in joining all the parties, my lord? The normal prudence says, my lord, whoever are the parties, we play the full game, my lord, with all the players, my lord. What is the necessity of playing second half of the game, my lord, only with few players, my lord? That was my first objection, my lord. And in that, to some extent, I am supported by this Gujarat High Court, my lord, and even the Punjab and Haryana High Court, my lord. Well, the Punjab Haryana High Court, the last page, my lord, the judgment. This was a reference answered by 3 judges, honorable 3 judges, my lord, of Punjab Haryana High Court.
Yes.
Page 1110, my lord, 110.
Yes.
It says, I would therefore answer the question referred to us as follows, that if a party to the original proceedings is not impleaded in appeal on account of a bona fide and honest mistake on the part of the appellant, the appellate court has ample powers under so-and-so to allow the mistake to be rectified and the party to be added. Section 1072, read with Order 1, Rule 10, CPC, enables the appellate court to add parties in appeal in suitable cases, but this power must be exercised within the period of limitation. That apart from the provisions of Order so-and-so, CPC, the appellate court has inherent powers to permit parties to be added to appeals in suitable cases, and the language or Rules 20 is not exclusive or exhaustive so as to deprive the appellate court. Now 2 and 3 talk about addition of parties, my lord. My lord, in my humble submission, 2 and 3 deal with a situation that because of subsequent development, for example, a suit was filed when during the pendency of the suit, so supposing that property has been alienated, sold it to some third person, my lord. Now he also becomes a necessary party, my lord. That can happen at the appellate stage. So though he was not a party before the trial court, my lord, but because of subsequent development, he becomes a necessary party at the appellate stage, my lord. So 2 and 3 in this judgment will deal with that, my lord. That appellate court has power to add parties. Here is a situation where that person was not a party in the original proceedings, but because of subsequent development, first part will deal with, my lord, the subclause 1 here, that basically more or less saying that all the parties in the original proceedings must be parties in the appellate proceeding. If someone is missed out, bona fide mistake, my lord, that it very clearly says, bona fide and honest mistake, then this honorable court can allow them to be implemented as parties. The converse, the reverse situation will be, my lord, if there was no bona fide mistake, it was done intentionally, my lord, in my humble submission, that will be fatal to the revision of appeal, my lord. So this was my first ground, my lord. And to that effect, my lord, I have taken your lordship to the array of party in the main suit, my lord. Because, for example, my lord, Mr. Philomen Nongri's client is not a party in the original proceedings, my lord. But your lordship is allowed to be implemented here because certain rights accrued to them, maybe. And because of that, my lord, though they are not parties in the original proceedings, though they have applied for impleadment in the trial court also, but that has not been allowed till now, my lord. Now, what is it come now? Yeah, I think so. No, my lord, the array of party in the suit, my lord, page 15, my lord.
Which?
Page 15, 1-5.
Yes.
So Khasil's Archery Institute was the plaintiff, my lord.
Yes.
The defendants were State of Meghalaya. Number 2 was Commissioner of Taxes, my lord.
Yes.
Then President Bookmakers 3. But only one thing.
This President Bookmakers, they have been
implemented subsequently, my lord.
Subsequently.
So subsequently, as of now, my lord, after the implementation, the other parties have come on board, my lord.
So 3 and 4,
3, 4, 5.
3, 4, 5.
6 has not come.
3, 4, 5 have now been impleted.
My lord.
Except 6.
Except 6, my lord.
So, Mr. Sen, you see, you have not made any objection to the intervening application filed by these parties here, 3, 4, and 5. So, accordingly, they have been impleted.
Lordship.
So, what is stopping you from impleting this number 6?
Like I said, my lords, their objection was under Order 41 Rule 20. That because of some imposition under Order 41 Rule 20, my entire application is fatal. It cannot be heard. My response is Order 41 Rule 20 itself says, I only need to make those people parties in my appeal, those who have an interest in the outcome of the appeal, not otherwise. It is not necessary.
Okay, that part can be looked into.
Lordship.
But now that the parties in the original suit has also taken part in these proceedings.
Yes.
So effectively, their objection would not lie anymore.
If Lordship recall, I did not make the other applicants parties. They came before
they
the court,
exactly,
and they filed an application saying they want to be heard.
True.
Lordships heard them. I said I have no objection because it appeared that they were trying to delay the proceedings. That's all. So only in the interest of not wanting this case to be delayed, I said I'm happy to have them made parties. Let them be on board. Let them be heard. So today they will be heard on that. As far as making everybody else a party, it is my case. They are not affected at all and they have no interest whatsoever in the original miscase which was filed before the trial court. No interest whatsoever. And I'll satisfy my lords on this issue.
That is one aspect, my lord. The second aspect, and which is equally important in the array of party lords, you will see, defendant number 2 is Commissioner of Taxes, my lord, who has come, my lord, Petitioner number 2 is additional commissioner, my lord. We are in civil proceedings, my lord. Commissioner is a statutory authority, whereas additional commissioner is not, my lord. But the entire act of Meghalaya, Tir, arrow shooting, my lord, revolves around the commissioner of taxes, my lord. So that is one defect, my lord, whether additional commissioner can, who is not a party before the trial court, my lord.
Okay.
So this is one aspect.
He has come as the petitioner.
He has come as petitioner number 1 is State of Meghalaya, my lord,
Yes.
and number 2 is additional commissioner. An additional affidavit has been filed subsequently by joint commissioner, my lord. So these are not writ proceedings, that's what I'm trying to submit, my lord. In writ proceedings, maybe that is permissible. Anyone can file on behalf of State of Meghalaya, but these are civil proceedings, my lord. So that is my one objection, my lord. So first objection is with regard to array of parties, my lord. My second objection is whether in the facts and circumstances of the case, Article 227 can be invoked, my lord.
Yes.
And my third objection is, my lord, that the order impugned is an appealable order.
Yes.
Passed by the assistant district judge, my lord. An appeal shall lie to the court of district judge.
So the impugned order is appealable.
It's an injunction order, basically, my lord. And against an order of injunction, an appeal lies, my lord, before the district judge.
Okay. Yes.
But if I may first elaborate on the third point, my lord, that this is an appealable order and an appeal should have been filed when there is an appellate remedy provided under the law, my lord. Much less 227, my lord, even 115 cannot be invoked, my lord. They cannot file a normal civil revision application also. 227 is again. Section 21, my lord. Save as a for certain appeal from a decree or order of Section 21, my lord.
21 of
Bengal, Agra and Assam Civil Codes Act. So, my lord, it talks about an appeal against a decree as well as order, my lord. And this being an injunction order, the appeal will lie to district judge, my lord.
What is the why have you referred to Section 21?
It says, my lord, save as aforesaid, an appeal from a decree or order of assistant district judge shall lie to the district judge.
This is with reference to the pecuniary jurisdiction.
Pecuniary as well as where the appeal will lie, my lord.
Originally, my lord, was 10,000. Now it has been increased to 60,000. This suit has been valued at 10,000.
60. Yes. So that's another of your
That this is an appealable order, my lord. they should file an appeal. And when appeal is provided, my lord, when a clear alternative remedy is there, revisional power, that too under Article 227 cannot be invoked, my lord. The Lordship will relegate them to a normal appeal under before the district judge, my lord. My lord, let's see the impugn order at page 138, my lord, is the application filed by us on which the impugn order has been passed, my lord. Page 138.
Yes.
This one filed an application under section 94 small e, my lord.
Yes.
CPC read with section 151 CPC.
Yes.
And the order begins page 152, my lord.
One 52.
152, my lord.
This is the impugn order.
Yes, ma'am. 8/8/22, my lord. My lord, an offshoot of this argument will be, my lord, that because there is a limitation period for filing appeal, my lord, the impugn order was passed on the 8th of August, my lord. For filing an appeal, there is a time limitation of 30 days, my lord. For revision, also there is a time limit, my lord. So to avoid that, my lord, what they have done, instead of filing an appeal or instead of filing a normal civil revision, my lord, they have trying to resort to Article 227 where there is no limitation period prescribed, my lord. In my humble submission, such an approach is to be deprecated, my lord. When to avoid limitation, my lord, you cannot invoke sort of writ jurisdiction of this under Article 227, my lord. This is offshoot of that, the main argument, my lord, that it is an appealable order. So appeal should have been filed. And why they have not filed appeal is because they are barred by limitation. Because this thing was filed on 15th December, my lord. Impugn order was 8th of August. So it was more than 4 months later, my lord, they realized. September, October, 4 months, more than 4 months, my lord. 4 months, in fact, 4 months, 1 week. By that time, the appeal was time barred. Even civil revision was time barred. And that is why they filed this revision, my lord, under Article 227, my lord.
You can explain any sufficient cause for delay or delay in filing. Give sufficient cause. Why does it delay?
My lord, they have referred to a decision of 2007, volume 2, my lord. They have relied on this. Bithika Majumdar. 2017, volume 2, SCC.
Have you filed any compilation, Mr. Sen?
Lordship, I have.
Yeah.
I have. Like, Lordship had taken Lordship through my entire compilation and served them a copy as well.
No, what is the first decision in your...
In that compilation would be State of India versus Ramkrishna Pandurang Barve.
State Bank?
State Bank of India.
Okay,
That
so
is my
this-
compilation.
And then there are others.
Not
But
sure.
there's no table of contents here.
Now, the judgment that they are referring to is at page 9.
Should have been some...
I apologize.
Yes. So,
in para 4, my lord, it says, my lord,
yes.
it is an admitted position in law that no limitation is prescribed for filing application under Article 227 of the Constitution. Of course, the petitioner who files such a petition is supposed to file the same without unreasonable delay, and if there is a delay, that should be duly and satisfactorily explained. In the facts of the present case, we find that the High Court has dismissed the said petition by observing that though there is no statutory period of limitation prescribed, such a petition should be filed within a period of limitation as prescribed for application under Section 105 of the Code of Civil Procedure. This approach of the High Court cannot be countenanced. As mentioned above, in the absence of any limitation period, if the petition is filed with some delay, but at the same time the petitioner gives satisfactory explanation thereof, the petitioners should be entertained on merits. So, my lord, what Supreme Court says, normally revision limitation is 60 days or 90 days, whatever, my lord. Appeal is 30 days. So, those timelines should be adhered to in case of 227 also, but not strictly in case there is a satisfactory explanation of delay. In the present application, my lord, there is no explanation at all, my lord. Not to talk about satisfactory explanation, my lord. So, my lord, on 227, what is the scope of 227? I'll give a compilation along with a short synopsis, my lord, by tomorrow afternoon. In fact, I argued in the beginning, my lord, then Mr. Sen replied to this. Today, just to refresh Lord's memory, because that was quite some time. If Mr. Sen wants to give a counter argument, I don't know. Because Mr. Sen's argument will be quite long, I know.
Oh, he has already finished his part.
I've already finished.
We'll give a written synopsis, my lord, in 2 or 3 days. Along with my only judgments on 227, my lord.
Mr. Tingra, what would you?
I fully endorse my colleague's submission regarding the maintainability of the petition, because this is under 227. Your Lordship will kindly remember, even in this Henel Singh Marat case, where Your Lordship had passed the judgment and has said that Your Lordship will come to para 26 of Your Lordship's judgment. Para 26 and 27. In fact, in this judgment, my lord, has held that an order, 27, my lord, an order by which an application for granting temporary injunction is disposed of, either dismissing or granting the ad interim injunction, can only be an order made in the course of a suit. That order, even if passed favouring or disfavouring one party, when the list is, will not have the effect of finally disposing of the suit. Similarly, when the matter is taken up on appeal before the appellate court, whatever decision made by the appellate court will only either be to allow continuance of the ad interim injunction granted by a trial court, or to vacate the same, which again will not be result in the final disposal of the suit. So in this case, my lord has held that even granting or not granting of a temporary injunction is not a final order, and a revision will not lie. In this case, my lord, what has happened, in fact, after the order was passed, the subsequent order was passed, which was stayed by the trial court, the plaintiffs here have filed an application for amendment of the pleadings to incorporate the subsequent event. In fact, that application is still pending before the trial court. And the order which has been passed by the trial court also is a continuance of the temporary injunction granted earlier. So they cannot come by way of 227. If at all, as my friend has pointed out, under the Act, an appeal will lie to the district judge.
From an order of the Assistant District Judge.
Yes, from an order of the Assistant District Judge.
May I just, I think I've already argued all these points, but just as a clarification, I need to address 4 points, Manoj. Number one, there was an argument jointly made and reference was made to Section 21 of the Bengal Agra Shillong Civil Courts Act.
Yes.
Well, Section 21, as Lordships have rightly observed, that provides for the pecuniary jurisdiction of the appellate court. Depending on the valuation of the suit, whether the appeal should be before the High Court or before the district judge. I'm saying here very clearly, I don't need to file an appeal. This is not an appealable order at all. Lordships cannot simply refer to Order 43 or 115 to decide whether it's an appealable order. That will be decided by looking at their application and examining the order that is impugned, not by simply referring to Section 21. Section 21 has no application whatsoever. That would come into operation only if I preferred the appeal before the wrong forum. Had my suit been valued above 5,000 and I preferred the appeal before the district judge, they could have rightly raised the objection that the appeal does not lie here, it lies before the Honorable High Court. That's not the case here. I'm very clear my application under 227 is maintainable. Next, my lord, they have said that 227 is not maintainable, only an appeal lies. And I think that is the crux of it. If Lordships will recall, in my compilation, I had referred to a judgment of the Honorable Supreme Court. Lordships will find that at page 26 of my compilation.
Yes. Yes. Para?
So, may I just take Lordships to page 36. I'll just read out the relevant paragraphs from here. My lords, it is my submission that Lordships will have to decide, respectfully, my lords, whether an appeal lies or not on the basis of what has been laid down by this particular judgment. Kindly have para 6 onwards.
Yes.
It reads that the CPC 1908 applies to all proceedings in courts of civil jurisdiction subject to any special or local law or any special jurisdiction under any law for the time being in force. The main feature of the court is its division into two parts. The main body of the court consists of sections which create jurisdiction, while the rules indicate the manner in which the jurisdiction has to be exercised. Section 9 states that the court shall have the jurisdiction to try all suits of civil nature except suits which are expressly or impliedly barred. Section 9 falls in Part 1 CPC, which deals with suits in general. Part 2 deals with execution. Part 3 CPC covers sections 51 to 64. Under Section 51 CPC, subject to limitations and conditions as may be prescribed, the court may order execution of the decree by delivery of any property specifically attached, decreed by attachment and sale, by arrest and detention, by appointment of receiver, or in such a manner as the nature of the relief granted may require. Therefore, attachment is a part of execution process. Part 3 CPC deals with incidental proceedings like power of the court to issue commission, letter of request, etc. Now this is relevant, my lords. Part 6 CPC deals with supplemental proceedings which cover section 94, which inter alia empowers the court to pass interim orders depending upon the circumstances prescribed by the rules. I emphasize on this part, my lords, it only depends upon the circumstances prescribed by the rules. And rules, the reference here is orders 1 to orders 51. In the case of Manohar Chopra, it has been held that the effect of the expression if so prescribed in section 94 is to prescribe the circumstances in which courts can exercise or grant a particular relief, and ordinarily the court is not to use its inherent powers to make the necessary orders in the interest of justice, but to see whether the circumstances of the case comes within the prescribed rule. Therefore, in a case where the plaintiff seeks temporary injunction, courts have to ascertain whether the facts of the case fall under order 39. Kindly take note of this as well, my lords. That it is in the incidence of exercise of power of the court to issue temporary injunction that section 94 has a role to play, and that section 94, however, does not take away the right of the court to exercise its inherent power. In the same judgment, section 151 CPC is also analyzed. The apex court in the same judgment has held that the inherent power has to be conferred upon the court by section 151 CPC. It is a power inherent in the court by virtue of its duty to do justice between the parties before it. That section 151 merely recognizes the existence of the inherent power of the court. Therefore, even if in a given case circumstances do not fall within Order 39 CPC, the courts have inherent jurisdiction to issue temporary injunction if the court is of the opinion that the interest of justice requires issue of such interim injunction. In the case of Ramchand and so, it has been held by this court that the inherent power of the court under section 151 CPC is in addition to and complementary to the powers expressly covered under CPC, but that power will not be exercised in conflict with any of the powers expressly or by implication conferred by other provisions of CPC. If there is express provision covering a particular topic, then section 151 CPC cannot be applied. Therefore, section 151 CPC recognizes inherent power of the court by virtue of its duty to do justice, and which inherent power is in addition to and complementary to powers conferred under CPC expressly or by implication. In the case of Jagjit Singh Khanna, it has been held that a temporary injunction may be granted under section 94C only if a case satisfies Order 39 Rule 1 and 2. Now kindly just take note of this one. This is very, very important. I'll just read this out again. In the case of Jagjit Singh Khanna, it has been held that a temporary injunction may be granted under 94C only if a case satisfies Order 39 Rule 1 and 2. It is not correct to say that the court has two powers, one to grant temporary injunction under section 94C and the other under 39 1 and 2. That section 94C shows that the court may grant a temporary injunction thereunder only if it is so prescribed by Rule 1 and 2 of Order 39. The court can also grant temporary injunction in exercise of its inherent powers under section 151, but in that case, it does not grant temporary injunction under any of the powers conferred by CPC, but under powers inherent in the constitution of the court, which is saved by section 151 CPC. Now, para 11 is the most important part. The above discussion shows that the source of power of the court to grant interim relief is under section 94. However, exercise of that power can only be done if the circumstances of the case fall under the rules. Therefore, when a matter comes before the court has to examine the facts of each case and ascertain whether the ingredients of section 94 read with the rules in an order are satisfied and accordingly grant an appropriate relief. It is only in cases where circumstances do not fall under any of the rules prescribed that the court can invoke its inherent power under section 151 CPC. Accordingly, the courts have to grant relief of attachment before judgment if the circumstances fall under Order 38 CPC. Similarly, courts will grant temporary injunction if the case satisfies Order 39. So depending upon the circumstances falling in the prescribed rules, the power of the court to grant specified reliefs would vary. Therefore, each set of rules prescribed is distinct and different from the other, and therefore one cannot equate rules of temporary injunction with rules of attachment before judgment, although all are broadly termed as interlocutory orders. Now, kindly have my revision application for Lordships to examine their application. Their application is at page 138.
Yes.
Kindly see the cause title at page 138 itself. It reads an application.
Yes.
An application under section 94E, not under 94C, my lords, which is why I was emphasizing on one particular sentence from that judgment, that an injunction will be granted by exercise of powers under 94C and by following the procedure laid down under Order 39. Here, they have sought to invoke 94E, and I'll take Lordships to section 94 as well.
Any other? What is 94C? E says.
Lordships, let's just kindly see the cause title once more, just to see what they've actually invoked. So it says an application under 94E of the CPC read with section 151. So they've invoked two powers. Now this judgment has clarified that section 94 is the jurisdiction of the court to grant interim reliefs. 151 is the residuary power of the court, inherent power of the court. So whenever a cases do not fall under 39 or 94, in that circumstance the court can grant relief under 151. Now this is a very important distinction, because I've also relied on a particular judgment in my compilation which says an order passed under 151 CPC simpliciter is not an appealable order. In such cases only a revision would lie. So a revision under only 227. Now kindly have the civil procedure code on it, just to examine section 94. Your lordships have it?
Yes.
That's supplemental proceedings. In order to prevent the ends of justice from being defeated, the court may, and I'm again emphasizing this particular expression, if it is so prescribed. I just pause here and take lordship to section 2 now. The definition clause. Kindly have section 2, subsection 16.
Yes.
The expression prescribed has been defined in subsection 16. It reads prescribed means prescribed by rules. And what are rules has been further defined in subsection 18. It reads rules means rules and forms contained in the first schedule. Well, the first schedule of the CPC is orders 1 to orders 151. So it reads rules means rules and forms contained in the first schedule or made under 122 or section 125. These are powers of the High Court to frame rules. We're not on that, Milad. So we're only on this issue. Rules made rules and forms contained in the first schedule. That is order 1 to order 51. So coming back to section 94, it says the court has the power to grant certain interim directions provided the rules provided, if it is so prescribed under the rules. Now kindly see C.
CO.
94C. The judgment that I was referring to has clearly pointed out and laid down that the exercise of powers or the procedure laid down under Order 39 emanates from 94C. So 94C reads, grant a temporary injunction and in case of disobedience, commit the person guilty thereof to the civil prison and order that his property be attached and sold. So the jurisdiction to grant these sort of orders emanates from section 94C and the entire procedure is laid down under order 39. In this application, they invoked 94E. Now kindly see what is 94E. Make such other interlocutory orders as may appear to the court to be just and convenient. Now it is for them to now establish under 94E which rules were invoked by the court, what procedure was followed by the court to grant that order, and only then we will see whether it is an appealable order. So if lordships have the provision of appeal under order 43,
Yes.
so I'm referring to order 43 rule 1, sub-rule R. So when it is said that my application is not maintainable and I need to prefer an appeal, my appeal would only be preferred under 43 1R because they claim it is an order of injunction.
Yeah.
So what this says, R says, an appeal will be preferred against an order under Rule 1, Rule 2, Rule 2A, Rule 4 and Rule 10 of Order 39. They never invoked Order 39. They did not invoke 94C, they invoked 94E. If Lordships see the entire order, the body of the order, Lordships will find there is no reference to granting of an injunction. None of the three ingredients necessary for grant of an injunction have been discussed by the court. I'm not on the merits, but just to indicate that the court did not exercise 39 or 94C. Court simply passed an order staying the operation of an order passed by the government. Now that was passed in exercise of its repository powers under section 151. And so therefore that is not appealable. If Lordships will have my compilation, I'll just make it very brief, my lords. On the issue of whether order under 151 is appealable or not, the judgment is at page 13 of my compilation, 1-3.
Yes.
The relevant portion, my lords, is at page 20. Page 20, para 18.
Yes.
This reads, it was not contended and could not be seriously urged that an order under section 151 simpliciter is appealable. Under the Code of Civil Procedure, certain specific orders mentioned in section 104 and 43 Rule 1 only are appealable, and no appeal lies from any other order. An order made under section 151 is not included in the category of appealable orders. So appeal is a creature of a statute. Unless and until the statute allows me to prefer an appeal against the order, I cannot simply prefer an appeal because they want me to prefer an appeal. Now, the judgment of Varijep very clearly lays down that the court will have to examine the nature of the petition, the nature of the order, and then decide whether I should have preferred an appeal or not. Now, they've also argued on the issue of Order 41, Rule 20. I believe, my lords, I have already addressed that point. They had referred to the decision of the full bench of the Punjab High Court. If Lordships will just have that again. Notified Area Committee Burai versus Govind Ram.
Yes.
Lords, here a question was referred to the larger bench of the Honorable High Court, and the question was, if a party's name is left out by bona fide or an honest mistake, can it be added, and to what extent would the rigors of Order 41 Rule 20 apply? The short facts here are that original plaintiffs were about 6 plaintiffs. They had challenged certain policy decisions taken by the Notified Area Committee of Burai. The suit was decreed in their favor, against which the defendant therein, that is the Notified Area Committee, preferred an appeal, which was the first appeal. The first appeal was dismissed, but while dismissing it, the court left out the names of one of the plaintiffs in the array of its parties in the judgment. So when the second appeal was preferred by the same parties, they simply copy-pasted the array of parties which appeared in the judgment and left out the main plaintiff. So subsequently an objection was raised under Order 41 Rule 20 that since you've left out one of the parties, your appeal is fatal. This is fatal to the appeal and it has to be dismissed. On this background, the court held that if it's an honest mistake, then Order 41 Rule 20 will not apply, because Order 41 Rule 20, the second part of it also provides that in case somebody has been left out and I realize that later and I wish to add that person, then the law of limitation will apply. But however, the court can dispense with that provision. Now that has no real application in my case, because my argument for Lordships is that under 41 Rule 20, The requirement to add parties is only if they have some interest in the outcome of the case. For instance, my lord, my learned senior is appearing for one of the parties. If lordships examine their application, lordships will find they have zero interest in this particular case. This case purely relates to and is confined to the license of the plaintiff before the trial court. The respondents have no role to play in that. They cannot be, and they cannot contend that they have any kind of an interest in that. There is a second judgment that they refer to which had supplied to lordship.
That's the Rajasthan case.
Rajasthan case, my lords. Now kindly see, in the Rajasthan case, there is no discussion on the application of Order 41 Rule 20. No discussion whatsoever. Now, the decision of the full bench of the Punjab High Court says Order 41-20 can be invoked and parties may be added. In that it says it is absolutely fatal. It is, in my humble submission, it stands counter to this particular decision and various other decisions. So I don't think that will be helpful in this present case because they do not discuss the application of Order 41 Rule 20 at all. And in any event, my lords, that decision is not binding on my lords, very respectfully. As far as Order 41 Rule 20 is concerned, I have referred to about 3 decisions here in my compilation. Kindly have the first one, my lords. State Bank of India versus Ramakrishna Panduram.
You have presented this argument before?
I have, my lords. I was just recapping it, but if lordships don't require it, I won't.
So that would be, as Dr. Mosika has said, it would be better for you to just give me
make a short compilation.
Written synopsis of your argument. That would be, then you refer to these authorities. Mr. Philemon is here.
My lord, regarding the maintainability, I have no objections because on merits, my lord, I'll be supporting the government.
That may kindly be recorded, my lords.
My friend
For the
has
future.
Said, my friend has said we will not be affected in any way. But my lord, we are all affiliated to Khasi. So if their license goes, our book making thing also will go. License.
We are holding the license.
We don't want to go to them. That's a different issue.
As I said earlier, question of ego comes.
Yes.
No, but I must also add, my lords.
Because we've been associated with them for 25, 30 years.
They're the new child of the government.
If lordships see the impugned order, there are only 2 parties who extended arguments in the Miss case. Nobody else. So a lot of people are saying that they have an interest in the matter, but they did not extend any arguments before the trial court.
In fact, my lord, we have filed an application also before the trial court for filing of a written statement, which they have objected. That also is under the consideration of the trial court. So most of the petitions are before the trial court.
But the original injunction that has been granted by trial court,
that has not been challenged by them.
Not been challenged till now. The subsequent orders are challenged.
As I was saying earlier, see, too many branches.
Yes.
Too many branches.
Exactly.
Our amendment applications are pending.
I think there are around 7 applications which are pending before the trial court. Anyway, we will give our.
All the parties have been heard in this matter. At the conclusion of the hearing, parties have submitted that they may be allowed to file written synopsis of their argument, along with authorities relied upon. As paper, release this matter after 2 weeks. This is with regard to 36.
36.
What about 11?
11 we can have it whenever lordships.
What is it? Is there an issue of maintainability and so on and so forth?
I don't suppose so. I'm not sure. Because that has not been argued as yet.
Are they distinct applications?
That matter, I had preferred an application under Order 7 Rule 11 for rejection of the plaint. That was argued by the parties before the trial court. Trial court held. My application was dismissed. So against that, I preferred a revision.
Maintainability will not be. We have not challenged that matter. It has to be heard on the matter. Okay, when it is after 2 weeks.
Let it come after this.
That's again a distinct issue. we had tagged along. I'm happy to start the argument if Lordships allow me.
Well, my
I'm
lord,
ready for
what
that.
will happen in that if Your Lordship allows this petition and everything goes?
Everything will go away.
Okay, if this, I mean,
Yeah,
you're talking about 36.
If,
11.
Lordship, if
No, no,
CRP 11 is hurt, everything goes. If Lordships allow my
even this-
revision application, then this suit goes.
Even this goes. Even this goes.
You should have.
So started
You
that
should-
way. You should have
You have
been the
started
other
that,
way.
yes.
But my friend is pressing for this because there are more.
No, well,
I think
because
some-
that CRP is an older
some rules
CRP.
in this.
It's been pending. Look at the number of adjournments, my lord. So I figured CRP 36 would be the best way to start. At least I can have their license issue decided, and then we can proceed further.
Yeah, this-
If 11 is decided in
Then
their favor, my lord,
this goes.
then 36 does not require,
Does not survive.
doesn't survive. That is better.
what do we do then? Should we?
Take up.
But both can go hand in hand.
It can, it can.
Because right now, my lords, on
No,
36,
no,
they
it
are
can,
not
but
wishing.
see,
My lords, kindly see this.
It can go, but the,
No, what I'm saying,
but the
in
fact is-
36, they're not willing to argue on the merits. They have raised maintainability issues.
Yes.
So that has only been heard. So if Lordships decide my revision in 36 is not maintainable, then 36 goes by itself. Then I'll rely and fall back on CRP 11. So because of this whole manner of piecemeal hearing, I've not been able to address my arguments in any of the cases. CRP 11, I'm ready. If Lordships fix it this week, I'm ready to argue that.
Let it be next week.
Yes, so let the court take a chance.
Okay.
Here, I'll hear this 11, and perchance I'm being able to dispose of 11 before an order is passed in 36.
But I
then
think in 11 also that
could-
issue will remain with whether all the parties have been arraigned as a party or not.
So Lordships are hearing that argument. I'll rely on the same argument again.
No,
No, I'll point
let
out
it be,
why.
But you said there's no issue of maintainability here.
But to
You
that
just said
extent,
that.
to that
So-
extent, I think will remain.
So
Let
again,
it come.
Lords,
Let it come next week, my lord. We'll address this.
Here also only.
No, I'll point out why. Because in CRP 11, before the trial court, I filed an application under 711 for rejection of their plaint. Nobody else has any say in that. Because I'm asking for rejection of the plaint.
Okay.
Because of that.
So
as I submitted, I'm on
your
very-
client is not involved. here.
Indirectly, we will, my lord, because Your Lordship will allow the petition. Our license also will go.
But you are not a party here.
They've not made us a party. That is a different issue.
So I stand by this that they're not required to be made a party.
But ultimately, if Your Lordship makes any decision,
You are, since you, as you said,
Yes.
you are under the umbrella of
Yes.
Dr. Musiga's client. What happened is he has preferred this suit.
they have preferred.
Who has preferred the suit?
The suit
He-
have been preferred.
he has
Yes.
preferred.
In suit, we have met them all of them party, my lord. In
In
our
the
suit,
suit,
all of them they are
we
party.
are parties.
Well, I am anticipating that this argument will be raised
When
again.
they come
May
to-
I just make a very quick submission, my lords? Similar to the other application that is CRP 36, 3 of them have been made parties. Let them all be made parties in this. By Lordship,
Yes.
Lordship has the power suo motu to make them a party. I have no difficulty in that.
In 11. So that
In
all
that,
of us
make them
are
all a
heard.
party. They can at least extend their argument.
Why can't the state file an application for that, my lord?
No, I'm saying,
Admit
I'm
their
saying very
mistake, my lord.
clearly, it is not
Admit
required.
their
It
mistake
is
and
not
what-
required. No, it's not a mistake at all. I'm not conceding.
Let
I'm
it
not
come on
conceding
next
that in 36 I've made any mistake. I'm very clear about it. Lordships may pass a decision against me, but as far as I understand, I may be proved wrong. CRP 11, my lords, all I'm also saying, the same course may be followed. They may all be made parties. And on the next day they'll be heard. I'll supply them copies today itself. Otherwise, my lords, it'll be adjourned again. That's the only issue. Just to save Lordship's time.
But can the court pass not to
Suo motu, my lords, Order 1, Rule 10 provides that courts have suo motu power.
Yeah, of course, but there has to be some, at least something on record.
If Lordships find, because they are connected matters arising from the same thing. So, and may I also point out, since in CRP 36 they've been made a party, this will follow for the trial court as well. They've been made parties in all the proceedings now. So it's just a matter of form, my lords. So they'll anyway which way have to be made a party. It's not a completely different case. These are all offshoots from the main trial suit, main title suit. So once in 36 they've been made a party, they become parties for
Well,
all
well,
proceedings for all intents and purposes.
By tomorrow, we'll file an application, my lord.
Order 1, Rule 10.
Oh, my lord, by tomorrow, we'll file an application for impleading ourselves. I
No,
think that
what I'm also saying, my lords,
No,
with,
one will
with
still
respect,
remain left out there.
no, with respect,
Number 6.
that what I was saying, the principle that I'm trying to place before the court is that once in a miscase, somebody has been party before an appellate court, before a higher court, then they become parties for all intents and purposes. They don't need to be made parties again and again and again. So I understand they were left out in this case, but it's not consciously because I mean, it is consciously because I feel they're not required to be made parties.
But now
if
do you
it
want
is
to,
going
now
to-
do you want to intervene?
Lordship. So if they want to intervene, they can be made parties. Lordship has sumo to make them parties. I have no difficulty with that. This is just to avoid a adjournment on the next date.
But number 6 still is not represented.
So there again, I'll place the decisions to show that they're not required to be made parties. But if Lordships want to make number 6 a party, I have no difficulty, because again, kindly see, Order 41 Rule 20 allows Lordships to make everybody a party.
You see, if number 6 is to be made a party,
then notice has to go.
Otherwise, you see, what happened is, okay, as far as Mr. Dingro's client or Mr. Philemon's Nongri client,
We are here.
we are here. So, you see, on the submission made at the bar, order can be passed.
Lordship.
But again,
6, I will show, my lords, that they have no interest in the outcome of this case as well. I'll show from the records as well.
Then who's to, you see, who is to...
No, because, my lords, they are before the court. With great respect, my lords.
Who's to stand in place of 6?
No, 6, I don't need to make them a party. I'll extend the argument that 6 is not required. They don't have any interest in this case.
So that will be the argument that 6 is...
State can represent number 6, my lord, if that is...
No. I'm saying that since my learned seniors are here and Mr. Nongri is here, they can be made parties in 11 as well. I'll leave it to Lordships.
Where's the indication here that they are, they are necessary parties here, or they have been read, as parties in the trial court?
The plaint.
Because the plaint is enclosed.
Plaint. Next year.
The plaint.
Page
50.
15. 15. No, this is 36. We're talking about this one.
The plaint is at page 22.
22.
No, 7-9. The revision I don't know who made.
Civil suits are really complicated. That's why they never come to conclusion. What do you say? That should have been his argument.
Order 10, see, even if you look at Order 10 Rule 2, it speaks of deletion or addition of parties in the suit.
So CPC does not apply strictly before these proceedings, but this is being carried over from the main suit as well. So if Lordship sees section 141 CPC, it says that the entire procedure will apply to all other proceedings as well. Kindly have section 141.
Suit means appellate. See definition of suit also there.
Suit is not only plaintiff.
141 is clear.
This will apply out of 40. 40.
Procedure.
Yes.
Lordship, I think let the matter come up day after tomorrow. We'll file an application by tomorrow. We'll plead ourselves.
That is
I think that's a better course of action.
So
11 let it be listed day after.
Fine. So no order will be passed here?
Yes.
Can you give 11 no? On premier well parties, this matter.
16th.
On 18th.
We'll file an application.
Ali Blair. Ali.
See, frankly speaking, I have lost touch with these civil matters.
CPC.
I've been out of practice for 10 years. So I have to entirely depend on counsel. So whoever rightly lead to court or mislead to court.
No, we will not. We will not.
Anybody's guess.
But as an
that is very unjust.
We should endeavor to simplify the things for us.
True.
It's very simple that when the trial match is played by 22 players ballot, the second match, so second half should also play with the same players ballot. Equal number of players at least.
Somewhere you see in the game, if you've
only
been,
to that extent,
if somebody has been given a red card, what do we do?
That is as per the rules, but intentionally, your 3 players will not play. You will play only 8, and we will play 11.
Everything has been sought to be confined within the rules. Fine. Thank you.
Thank you.